this award is given out each year to the company that has the best online delivery of legal documents. I'm going to say that again. The best online delivery of legal documents. That's from the American Bar Association. And still to this day, we are the only ones in estate planning to win this award. So not LegalZoom, not Legal Shield, Trust and Will. None of those have won this award. So we're very thankful and very honored to have won that award. And this is all of the documents that you get. This is everything that you receive in our full premium probate avoidance package. Now, as you can see, all of these documents are for both spouses. So one plan covers both spouses. And again, you receive all of these documents on the right-hand side of the page. And let's talk about all of the documents that you get, because as you read through there, you've probably heard of a lot of these, but why do you need them, right? So let's start, and I will always clarify, you know, when we talk about estate planning, a lot of people say will and trust, right? Like it's one document, but let's remember that your will and your trust is two separate documents. So we're going to talk about them separately. Your will, let's talk about your will first. So your will, there's really 4 reasons why we create our will. One, we're going to name executors. Your executors are the people who are going to be in control when you pass away. These are the people that are going to handle almost everything. They're going to handle the distribution of your assets, getting any children to guardians. They're going to pay your taxes. They're going to pay your bills. They're going to make sure that everything is settled with the court when you pass away. Again, you can name a main executor, and then you can name alternates as well. We will always recommend that you have at least one person from the state that you live in, because if something happens unexpectedly, they can move in right away. Number 2, guardians. If you are a parent of an underage child or children, something happens to you and your spouse, a car wreck, a plane wreck, both of you get sick. Who's going to take care of your kids, right? So, like I said in the beginning, job number 1 of any parent, let's take care of our family. Having those guardians listed, again, if something happens to both spouses, so those kids don't go through foster care, they don't go through the state system. They get directly sent to a guardian of your choosing. Number 3, specific bequest. And what that simply is listing all of our assets and who those beneficiaries are. Very, very important. We want to make sure that we're listing all of our major assets and who those individuals are that will be receiving it when we pass away. The 4th reason is the second line item there, children's trust. This is where you get to dictate at what age and how much of the inheritance you left for your child they will receive. And you can spread this out all the way up to age 35 if you choose. So you dictate at what age and what percentage of your child's inheritance they will receive starting at the age of 18. Third line item is our durable financial power of attorney. I think we all know what our POA is, right? Naming someone who can make our financial decisions for us if we can't make them ourselves. One big thing to remember about this is a living document, right? They can only act on your behalf as long as you're alive. So if you need someone to pay your bills, pay the rent, stock votes, anything like that, they can act on your behalf if you can't do it yourself. The next 3 documents are our healthcare documents. And what's really important is not only are we taking care of your financial obligations and making sure that they're taken care of, but we're taking care of your healthcare decisions as well. Your healthcare surrogate is your medical POA. Who's going to speak for you when it comes to matters of healthcare? Talking to doctors, nurses, insurance companies, deciding what's going on, right? Again, main people and alternates as well. We're keeping you in full control of who can act on your behalf. HIPAA authorization allows your healthcare surrogate to see your medical documents. So any kind of medical charts, anything like that, they can see so they can make an informed decision along with the doctor. And your advance directives, end of life decisions. Do you want to be hooked up to a machine or not? You know, some people say, yeah, keep me alive. Maybe there's a certain amount of time. Or others, hey, no, if it got to that, just go ahead and let me go naturally. Keep me out of pain, of course, but let me just go ahead and pass naturally. The one key thing I want you to remember about why we're doing this, again, is to keep you in control of all the decision making. That's why we do this. We even have a pet trust. So if you're a pet lover, great. You can leave money behind for the well-being of your animal. And then the last document, the revocable living trust. And this is a probate avoidance trust. So let's talk a little bit about probate. Now, first of all, probate is a bad word. We never want to send our executors and our beneficiaries through the probate process because, one, it's time consuming, it's very expensive, you have to hire an attorney, you have to go to court. But what probate really is where the government steps in because you didn't have a revocable living trust in place. The government steps in and freezes all of your assets. And the reason that they do that is so creditors have a certain amount of time set up by the state law for them to come in and put a claim on your estate. If you owe someone something, a creditor, that has to be taken care of first before all of your assets get distributed to your beneficiaries. Here's the key thing. Probate usually lasts on average about 8 to 12 months. So that means assets sit there not being distributed to your beneficiaries. But if there's mortgages, car payments, anything like that, businesses that have to be taken care of, guess what? Your surviving spouse, your kids, they still have to pay for all that. They don't gain access of it, but they still have to take care of all the bills. The bills still have to be paid. So making sure that not only do we have our will, but our trust in place. The trust is the only document that will keep you out of probate. Now, let's talk about funding the trust, which is very important. It's not just about creating this document. It's about transferring your major assets out of your name and into the name of the revocable living trust. So the revocable living trust will own these assets, but never fear. You are always the trustee of your account for as long as you're alive. You lose no authority or power. So it's real easy. You just do a deed transfer of your house. A business, you just change it out of your name and into the name of the trust. We have funding instructions that walk you through how to do all of this. But what we want to make sure is not only do you create this document, but you actually do the funding or the transfer of that asset out of your individual name and into the name of the trust. And we even have a 7-day money-back guarantee. If you try it out for any reason you don't like it, no worries. We'll give you your money back as long as you haven't downloaded any of your documents. All of this, again, for both spouses, our cost is $600. In our law office, this starts at around $3,500. 1/6 of the cost, and people will always say, well, why is it so expensive or inexpensive? We've already paid the attorneys. That's the biggest thing. You have to pay the attorneys, right? We've already done that. What you're doing is you're getting a document creation system where you can create all of these documents for you and your spouse. Not only that, the second reason that separates us from everybody else, remember the first one was the James Keene Award from the American Bar Association. The second one, you have the ability to go back into your account at any time free of charge and edit any of the documents. I call them life events. If something happens in your life, don't worry. If you have another child, another grandchild, you move from one state to another, you have the ability to go back into your account, edit your documents free of charge. Just remember, anytime you do that, you have to print them out and get them witnessed and notarized again. And you're done. The days of going back and forth to the attorney's office, paying $400 or $500 every time you have to change a document, that's over. State-specific legal documents that you can create in your home for you and your spouse, and the ability to create and edit the documents at any time. So we've talked about what net law is and why we were created out of our law firm. And we just went through all of the documents, and you even have the ability to edit the documents at any time. But the last 4 slides that I'm going to show you, and then I'll answer any questions that you have. we're going to talk about what happens if you don't do this. We understand the importance of this, but we still procrastinate. Something happens, we pass away, and we don't do this. What happens now? A lot of people assume that anything that we own as an individual just goes to our spouse. And that's not true here in the US. I think Theroux said it best. You have to follow the law of the land when he was doing the introduction. That's true. So the only legal term that I'll use this morning is intestate. And intestate means that you passed away without a will. The government doesn't know how you want it to distribute your assets. So guess what? They're going to do it for you. Intestate simply lists, and there is intestate for every state. So each state is different. But in Kentucky, where I'm from, if I passed away without a will, and for my individually owned assets. Now, joint assets, if I owned something with my wife, I passed away, of course it's hers. If she passed away, it's mine. But what we're talking about is individual assets. If your home is just in your name, businesses, cars, 50% would go to my spouse, 50% would be split between my kids. In a lot of states, it's a 50-25-25 split. 50 to the spouse, 25% to the kids, 25% to your next closest living relative, which could be your mom and dad if still alive, grandchildren, brothers and sisters. The state is dictating how your assets are going. No one wants that. I guarantee there's 24 of us on this call. I guarantee no one is saying, I really want the state to come in and decide that. But they will if we don't do our last will and testament. Same with our guardians. If we have children under the age of 18 and mom and dad pass away, a judge will come in and decide who gets custody of your kids. A judge. Again, I can almost guarantee that all 24 of us are shaking our heads like, that is not what we want. That's why the will is so important. We're going to list who's going to take care of our kids. Not only take care of our kids with custody, but this is the person who's going to be responsible for their inheritance. And I think as parents, we know who's best to raise our kids, right? You don't even have to stop and think about it. I can almost guarantee that all of us would say, I would pick this person. Because we know. Judge doesn't know. They're just going to look at family history and who's got enough money to take care of them. Making sure it's the person of our choosing. Very important. And I talk so much about probate, and I can't talk enough about it. At all costs, we want our beneficiaries to avoid probate because, again, you do have to hire an attorney to go to probate court. And whether you go to probate or your attorney goes for you, it's still going to be very expensive. And there's no reason to have those assets just sitting there frozen by the government when we have the ability to just create a document and transfer those assets into the name of the trust. Making sure that everything is taken care of before we get sick, before we pass away. And again, I'm going to say it again, keeping you in control. My last slide. Don't skip out on those medical documents. I am a big advocate of these documents. Having someone as your medical power of attorney so they can speak for you if you can't speak for yourself is very important. Take it from me. I know firsthand. And knowing what you want to do at end of life. If you can't speak for yourself, having the ability to have someone say, this is what he or she wants. This is what he or she does not want. And here it is written down in their advanced directives. Again, we're taking care of everything. Financial and medical documents, all prepared. State-specific legal documents, award-winning by the American Bar Association at a very, very reasonable price. And again, for both spouses to create this documents, it will take you about 30, 40 minutes tops. The great thing is we have a great customer service. I would get with Raghavir. If you have any questions, how to get started. He can answer any questions. And if he can't answer anything because he's not an attorney, he can call me up. He has my phone number. We have a great customer service area. The great thing is we have a chat bar in the upper right-hand corner of your NetLaw client account. If you hit that chat, you can speak with us and we can turn that chat into a video call if we need to see your screen. So we can see what you're looking at and help you with any questions or help filling out the documents in any way. All of our customer service is free of charge as well. Most companies charge anywhere from $10 to $30 a month for the ability to access your account and edit those documents and customer service. All of ours is free. So let me go ahead and stop here. This was what I call Net Law and Estate Planning 101. So you just graduated Net Law 101. So let me answer any question. Raghavir, I will turn it back over to you, or Thiru, I don't know who's going to take over, but let me turn it back over to you. And if there's any questions that anyone has, we'll go ahead and answer those.
Sure. Mark, this is Sandeep here. I've received a couple of questions. Is that
Sure.
okay?
Yeah, absolutely.
Right. So one question was, I'm residing in Atlanta right now. What if I change the state? Do I need to do the estate planning all over, or can this be modified accordingly?
Yeah. The great thing is you would just log back into your account and go back into your My Profile section. Your My Profile section is just your name, where do you live, are you married, stuff like that. So you would just go in and change your address. So let's say you're in Georgia now, but you moved to Texas. All you have to do is go back into your My Profile section, change your address. The system will update the Texas documents. Just start over. Hit your last will and trust document. Just run back through it, because every state, remember, asks different questions. So some states may ask a question, some states may not. So you just want to run back through the software again, answer the questions again. If there's anything that you need to change at that time, great, go ahead and make that change as well. But you can do that at any time.
Thanks, Mark. Another question I received is, what about the India assets that I have? Do we need to include all that as well?
Absolutely. I would list all of my major assets, whether they're foreign or domestic. Now remember, if let's say assets are still in India, of course you have to follow India law over there because that's where the assets lie. Okay. But the reason that you're putting them in your US will and trust is so that when something happens, your executor has a list of everything that you own. So nothing gets skipped over there. If you own a lot of land, right? Your executor may not know that. We don't want anything to get skipped, right? So it's always good to have your will and trust over here and your will and trust over in the other country, whether it's India or wherever the property lies.
Thanks, Mark. Those are the couple of questions. Audience, any other questions from your side? You can unmute yourself and go ahead with the questions.
Yeah, I have a question. This is Ram.
Mhm.
Am I audible?
Yes, I can hear you.
Okay. So my question was, do we have to list all the properties that we own in the will, or can we just add it as an addendum, which we can keep changing?
Yeah. So
Let's say I have rental properties or things that I keep changing, or I keep buying and selling things. I don't want to keep changing my will all the time.
Yeah, there is a memorandum form inside your account that is kind of like a Word document. You can just take out and leave. What I would do is list as many as you have right now. Right now, currently, if you do it today, list everything in your documents. Moving forward, you can have that in your memorandum.
Oh, got it.
Hey Mark,
Okay, that helps.
Mark, this is Moti. I have a question.
Okay.
So do we need to do everything in one shot, like will and trust and transferring the funds? Or let's take an example. I wanted to start with NetLaw as a will first, then I can continue with the trust and everything, right?
Well, yeah, you could do that. Now, of course, we're going to tell you because we don't know what's going to happen tomorrow, right?
Mm-hmm.
So we're going to tell you, yeah, you should do all of this right away as soon as possible. Now, if it's a week or two later, it's okay. This is your account. You do it according to you. But the one thing that we would hate is, God forbid, you start but don't finish and
Mm-hmm.
something happens, right? So we
Right.
always want to err on the side of caution. But you're right. You could do it on your own time schedule.
Okay, thank you. So one more question is, say, let's take an example. I've done everything now. Whatever I think you just suggested, list down everything, whatever you want to include it as a part of will and trust.
Yes.
Okay. So once we have it ready in the online, so then we have to take that and notarize it and keep it, right? Just for our reference. Every
Yes.
time when we make the changes, we have to do the same process, correct?
Correct. And the great thing is inside your NetLaw client account, there's a section called My Files where you can actually scan those documents back in. So you have a digital copy, but you have your hard copy as well. And those digital copies, I would send a copy to my executors, my guardians, adult children, brothers and sisters. So in case something happens, they have a copy of it ready to go.
Okay. Yeah, thank you. So sorry, this is my last question.
That's okay.
So when we list down, right, in case of will and trust, okay, after myself and my spouse, who is going to take care of my kids if they are minors, right?
Yeah.
So can we list down those guardians outside of the country too?
Absolutely.
Okay.
Now, I would always suggest that you at least name one person. Now, you and your spouse are not guardians of your kids. You're
Yes.
their parents, right? So when we list someone, I would at least name one person from your state, because if you and your spouse are in a car wreck and pass away, they can go grab the kids right away.
Okay, within the state is fine. Outside the state is also okay.
Within
as
the
long as we
state,
are in the US.
Yeah, anywhere in the US. Anywhere in the US.
Okay.
Because
got
it's a lot harder to get over here from India than it is to catch a plane from California to
Got it.
Texas, right?
Yep.
Yeah.
Got it.
Yeah, the last thing we want is the kids going through the court system, because that's never good.
Yeah, we wanted to avoid that.
Yes, we want to avoid that at all costs.
Yeah. Okay, thanks, Mark.
Yeah, thank you.
So continue to the same question. So can we give more than one person name from US? Suppose if the person name, the person is not available, so the second person can able to take the charge, right?
Absolutely. Yeah, absolutely. You can name as many people as you want.
Yes. Any other questions? Yeah, Chandrasekhar, go ahead.
Yeah. So this is this whole process is just one time, or we need to do this every year?
It's just one time. So you create it one time, but of course, if there's anything that you need to go back and edit, you can do that.
Okay.
But if you fill it out one time and there's never any changes, you're good.
Okay. And if the state law changes, you will be taking care of that? Or?
Absolutely. If any state laws change, we send you an email and a certified letter letting you know that there's been a change to the wording of any document. You can just go back in there and reassemble your documents, and it'll have all the new language.
Okay. Thank you.
Yeah, hey, Mark, one quick question. Suppose, my company, like my LIC or my policies, right? My bank accounts, so all these accounts, like, if I declare my beneficiary, my wife and my kids, okay, and something like, accidentally something, we did not do the will by the time and something happened. So those accounts will be freeze, or will it goes to the, like, beneficiary automatically?
Well, for your life insurance, 401k, stocks, those will pass to your beneficiaries right away because they all have named beneficiaries on it.
Right.
So I would highly recommend everyone go down and put a named beneficiary on your bank account. Then that would pass. So anything that has a named beneficiary avoids probate automatically. But what we're talking about is your major assets, like your home, cars, rental homes, vacation homes, businesses. Those don't. So those are the things that we want to put into our revocable living trust. And
Right, exactly.
yeah, you're right. Any of your other accounts that have named beneficiaries, they pass to your beneficiaries right away.
Great. Thank you.
Uh-huh.
Hey, Mark, this is Sandhya. I
Yeah.
have a question. So,
Uh-huh.
if we have all our properties and everything, we have a beneficiary assigned, and if we just create the will that to take care of the kids, do we still? I mean, what is the benefit of doing the trust in this case?
Yeah, so for your property, there's not a way that I know of anyway to name a named beneficiary. That's not in
I
any
mean,
of the
properties
documents.
we have like a joint houses on joint names.
Yeah, so if you pass away, then it would be the other
Yes.
person, so if you and your husband own a property together,
Mhm.
right, together, you pass away, it's still his house. If he passes away, it's still your house. But what we're talking about is individual properties.
Okay, so
But
if we have
you
only
still need to put it in your trust, because if you pass away and then, let's say you all live to a great age, right? You're in your 80s. If you pass away, then he passes away. It still needs to be in both of your wills and trust so that it gets to the kids right away.
okay, so yeah, if something happens to both of us, then it would be
Yeah,
yeah.
right.
So yeah, I still want to kind of understand like the beneficiary or of trust over will. I mean, benefits.
For your will, when you're listing about your beneficiary, so all of your assets that you're listing in your will, you're listing who gets those assets, right? So in your trust, there's no beneficiaries in your trust. What you're doing is just transferring, the trust is just transferring those assets out of your name and into the name of the trust. So here's a good way to think about it. Your will is a listing document. Your trust is a holding document. So for your trust, you're just transferring those assets out of your name and into the name of the trust. That's all you're doing. In your will, you're listing everything and who those beneficiaries are. Now, they work together, but they're still separate. They do two totally different things.
Okay, thank you.
I see a question in the chat. If my organization provides legal insurance that I pay for monthly, would that offer me this will and trust process for free or for better rate?
Well, I don't know. You would have to ask them. I don't know how long you've been paying for that, and if you've ever done it. So, I mean, that is not us. We don't do employee benefits at all. But what I always tell people is, if you buy this, I would ask your HR person. I would go to your HR representative and say, I want to buy this instead of using my employee benefit. If I buy this and give you a receipt, will you refund me back? And usually they say yes, but ask them first before you do anything. But there's no reason. I mean, I don't know how long you've been paying for this or if you've ever even done it. So you may have just been, throwing money away. So either or, let's get it done.
Good. Yeah, I will take a few minutes to help summarize the session, right? So this is Tirmal Reddy Kambam, and thanks, the great organization GATES, our Greater Atlanta Telangana Society. They have been very cautious and thoughtful to schedule this kind of seminars, webinars to educate the community, and appreciate everyone taking time on the weekend to know and understand the importance of protecting the family and what and how to take steps. So thanks, Mark, for your time. So I will give you a little summary in the 3 to 5 minutes about this whole process, what I explained. And also, I want to ask the question, see, if you really wanted to do this, if yes, why? And kind of thing, right? And I'll just share my screen and put some questions in front of you. Okay, then you decide whether you need it to do or not. If you think that you need to do, protecting the family is a priority, not like a choice or option. Okay, these are all the 10 questions. Very, very simple questions. Okay, even one question, no. Your answer is no for even one question. Okay, that's where we need to prioritize and take the action immediately. Okay, so you can go through the questions and each one of you, and you know the answer better for your situation, and then that is the one main reason for you to do this on a high priority basis. Hope you're all looking at it. Whoever complete the questions or 10 questions reading, just give thumbs up in the Zoom chat. That would be really helpful, so that if more than 50% get the response, means we assume that is done. Please, Sandhya garu, Chandrasekhar garu, Ranjita garu, all, like, yeah, please give the thumbs up once you go through the questions. It's worth of taking a few seconds to read all the questions. See that? Thank you. Thank you for those who is responding. Padma garu and Vasanta garu and Sanjay garu. Appreciate. Yeah, please keep going on, Chandrasekhar garu. Just keep going on
Yeah.
the questions, answering yes or no. Even once you complete the questions, you know the answer better. You don't need to disclose here. All I want is the thumbs up once you read the questions. Thanks, Chandrasekhar garu. Okay. Yeah, I expect at least a few more, so that we can go to next level. Nagaraj garu, and good, pretty good response. Appreciate that. Keep going on. One more minute. Yep. Yep. Thank you so much once again, taking time to go through these questions, and you know the answer better and right. So now you prioritize this. Okay, now I'm going to summarize these things. And so once again, the disclaimer is I'm not attorney nor CPA to give the legal advice. I'm sharing my experience and knowledge with you to educate you to the point you understand the importance of protecting the family and prioritizing that. Okay, so here many people have the questions that, will and trust. What is a will? What is the trust? Will is the legal document where we define the key people and assign the roles and responsibilities. The key people can be anyone 18 years and above, the whom you trust the most. Parents, siblings, relatives, anyone. It doesn't matter what status they have, where they are in the world. Okay. The key people criteria for the eligibility is 18 years and above. They can be anywhere in the world. They can be, what are the status they have it, doesn't matter. Then all as long as you trust them the most, because they're the one who is going to be part of these roles and responsibilities. What are the roles involves here? Executor, guardian, and trustee. Okay, the most important powerful role out of these three roles is the executor, who makes sure that executes accordingly in the document. And the guardian is a person who takes care of the kids while the absence of both the parents. The trustee is the person who manages your trust, your absence. These three are the most important. Can the same key people can be in all the three roles? Answer is yes. Can we have any number of the key people in each role? Yes, answer is that. Can the people can be anywhere in the world to be play that role? Yes. But we recommend, based on our experience and the input from the clients, we recommend that make sure that the people who lives in within USA, at least 50% of your number of key people you are assigning into this process. This example, you are putting like 5 people, 7 people, 9 people, right? Have at least 3 to 4 people be local to USA. It doesn't matter what status they have it, because you trust them. And so that's very important, so that they can come immediately into the situation, take the situation into the control by taking the kids if there's something happened to both the parents, right? So that is one of the main reason we recommend to have at least 3 to 5 people, or 3 to 4 people, or 2 to 3 minimum have the local to USA. Some states demands, like Virginia demands that executor of the whoever play the executor role, they must be specific to that particular state. Okay, this is a basic information we need to be aware of it. Mark gave a wonderful presentation. He answered the questions. Now, what is the next? This is what I'm sharing. The information is the next. Go through the questions, find out whether you need it or not. If you need it, this is how you need to do. Okay. Then now it comes to the trust. What happens if you don't have the will? If something happened to both the parents, the younger kids, minor kids end up in the foster care. Why and how? If you don't have the will, government has the default will. Government decides your kids' future. First, first they park the kids in the foster care, then next formalities. Is there any possibility they can give it to our parents and siblings like that? They don't have any history here. So you may need to be very cautious. Yesterday we were in the Texas, like Telugu Cultural Association asked in big event, many people are asking the questions. We feel, they are not aware of it. We are busy with so many things, the job and other things we overlook. So be cautious knowing about it, irrespective of our visa status, financial status. Okay, everyone must follow the law of the land. One of the question asking that, my kids born in India, is it still they need to do will and trust? It doesn't matter where our kids born. Okay, where we born, it doesn't matter. As long as you're in this country, you must follow the law of the land, right? Do you agree with it? So that is the will is the legal document where we define the key people and assign the roles and responsibilities. And if you don't have the will, government has the default will. Government decides the kids' future. The minor kids, if the something happened to the parents, minor kids even the end up in the foster care, which is not worth to take that kind of risk. What is the trust? Trust is the logical and legal entity. The main purpose of creating the trust, especially family revocable living trust, main purpose of that is to avoid the probate process. Why we need to avoid the probate process? Because there is a process to go through. It costs some lot of money. It takes a lot of time, as Mark mentioned, right? Anywhere between 6 to 12 months, depend on the state. North Carolina 3 months, Texas 6 months, California more than that, right? So what happens during that waiting period? Government publicly advertise the deceased people's information that hey, any liability, please come and claim. So you are putting entire things at the risk. What happens? No one comes. It goes to the state. So why we need to avoid the probate process? It costs a lot of money, it takes a time, and your information will be open to public. It's not worth it. We maybe see our small beautiful house is itself with a big bungalow. Some people used to say, "Hey Tirmal, we don't have big bungalows and millions of dollars, my friend, to do the will and trust." I said, your bungalows, your sweet home is your bungalow. Whatever the money you have in bank account is that is a millions of dollars. And more than these two things, your kids is the best, most important assets in your life. I believe that. Do you? How many of you believe that our kids are our primary assets? If you believe in that, like me, you don't even think second thought. Okay, go and do it that. So the trust, importance of the trust is to avoid the probate process, to protect your assets, make it your assets more private and secure. And how to do things in the trust, right? Once you form the trust, means no tries, and the trust identification could be your SSN, right? And there are multiple types of trust, but we strongly recommend to have at least minimum family revocable living trust, where you both wife and husband jointly can form the trust, and you can fund the trust with your assets. What are the assets to fund the trust? It could be bank accounts, it could be brokerage account, it could be personal home, automobile, everything, all those things. There are only few exceptions in the anything retirement account where we define the beneficiaries. Okay, life insurance where we define the beneficiaries. There are those places. Bank accounts also sometimes we can define the POD beneficiary, payable under the beneficiaries, right? That also help. But even though all those things have the beneficiaries, what happens if the parents something happened to the parents when the kids are minor, right? Those things will be stuck there. To avoid the things, we still recommend Okay, as long as you have the minor kids, even though the minor kids are the contingent beneficiaries, because we define the one of our friend Chandra or someone said that, hey, I put my wife as the primary beneficiary and my kids as the contingent beneficiary. What if something happened to the parents, both of them, when the kids are minor? The funds will stuck there, right? They need to be a certain age. Mark, please correct me if I anything, I'm just sharing my experience under your guidance. I helped thousands of families, right?
No, you're right.
Yeah. So keep these things in the priority and fund the trust, whatever the logical legal entity we are forming through this wonderful Netla software, and fund the trust with our assets. Assets can be bank accounts, brokerage account, personal home, automobile, any all other things, retirement, insurance, all the things also. Nothing wrong keeping the beneficiary of the trust, so that the successor trustees whom we trust the most, we defined as a successor trustee, they have the access. If something happened to parent, then they can get the funds and use it for the kids minor to help them to fund to their college and all the things, and then distribute. Okay, never ever, I mean, you always trust and verify, and take action towards it. Action only gives the results for anyone. Don't postpone it. If you go to the single party get together, it take a 4 to 5 hours. You all know that. The whole process can be done within 2 hours. Entire process most easily, efficiently, thanks to Netla and the dynamic team, Mark and all the team who supports on the timely manner. This is the how I would think of it, my friends. Okay. And so one of the friend was asking that, I have the legal plan at work. Yes, that's a great idea. Appreciate that. It doesn't mean that you have the will and trust. Okay, connect to the portal, generate the legal documents, and continue the entire process like notarizing them and scanning them, sharing with the key people, and fund the all the things you should be done. During that process, if you need any help, we will be happy to help you. Okay, our services are absolutely guaranteed, no fee, no obligation. And we want to let you know that we also provide further more services to complement and to give the 360 degrees protection for your family with the kind of like, kids college funding, life insurance, retirement solutions, all those things we provide. The consultancy charge is nothing, no fee, no obligation. More than all those things, yes, we are looking for the, team of financial professionals to build. If anyone is looking for the opportunity and a second career, please feel free to reach us. We'll be happy to help. And thanks, Raghu, for coming forward to offer all your GATES, society, your society's friends, to give the $600 package for just 300.
Yeah.
Thank you so much, Raghu. You are very thoughtful. I know you are in the community, you are for the community. And giving $600 worth of package, getting that to the 300 for your, our great Atlanta, Telangana society, friends and families and members, lifetime members in that organization. Very thoughtful. That is the best deal. Nothing can beat that. Okay, once again, thank you for giving us the opportunity. We are on time, 1 hour, okay, and this is extra. Any hour we are complimentary to address any questions related to this. I'll be very happy. And American style or mark covered maximum, and I'll see my best to address any questions you have it. Thank you once.
There one question from Sandhya Garu. Does having trust has any maintenance cost or on monthly, yearly basis?
Great question. Sandhya Garu, actually there are multiple types of trust, Amma. So the one we are talking about is the family revocable living trust. Okay. For this trust, your SSN is the trust identification number. So there is no such additional cost to maintain that. But there is another trust called irrevocable trust. Okay, depend on the net worth and the need. You can also have that. You can take a one-to-one appointment. So we do the financial analysis and then we recommend whether you may need it or may not need it. So the irrevocable trust needs additional maintenance yearly. You need to see what is in, what is out, what is the growth, a kind of tax kind of thing. But the one we are recommending, every family must have the basic and important thing, family revocable living trust does not need monthly or yearly maintenance things. Mark, please acknowledge, correct me.
You're right. Yes, there's no additional fee. Once you get this program, the trust is included, any updates are included, all of that free of charge.
Thank you.
Yeah, and another thing, the extension for this, right? This trust part, whatever the assets Mark mentioned in the earlier screen, so whatever the assets we have till date, you fund to that. Going forward, okay, you're buying the new property, okay? During the closing time, 1 week before, they will ask you, the title company closing company will ask you, hey Sandhya, do you want to put in your name in the deed, or you want to put any LLC or trust? So that time you can share this certificate of trust, so that without any modification to this trust we formed, they directly put that warranty deed or quitclaim deed, would depend on the state specific. They put your trust name there instead of putting Sandhya's and Sandhya's husband name, like that. Okay.
Thank you. Thank you, Tirmal Garu and Mark and Raghuveer for coordinating this real quick. Thanks.
Yeah, thank you.
Any other questions? Yeah. Thank you, Mark. Thank you, Thirugaru. Thank you, Sandeep, for arranging the call.
Sure.
Yes. Yeah, you can reach, if you have any additional questions, you can reach out to GATES and we will answer the questions.
Hey, Raghu, one thing before we leave, right? If any participants join directly, right, ask them to leave their email ID so that we can send the recordings or like future communications out.
Yeah, sure.
Request to participants, please drop in your email in the comments so that Raghu will take care of those, and then we'll communicate all the details with you in future communications. Thanks again. Thanks everyone for joining in.
Yeah, thank you all.
Raghu, please do collect those. Okay.
Sure. Yeah, I'll collect.
Thanks, Tirmal Garu, for your time.
And my pleasure, and all credit goes to Raghuveer and you guys, because you are the one who coordinated, and me and Mark is just supporting. So we do our best. Thanks for giving us the opportunity, Sandeep and team.
Okay.
Ismail Bhai joined late, and so feel free to reach Raghu. He will help you, with any further assistance.
All right, everyone, have a great day. Talk to you all soon.
Thank you all.
Excuse me, sir.
Thank you all. Thank you very much.
Thank you.